In this episode, I visit with Greg Keating, and we discuss the current whistleblower scene in terms of regulations, case law, the Biden administration, and where Greg sees whistleblower bounties going.
This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
The FCPA Compliance Report is a production of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back for another episode, and you're in for a real treat today because I have with me Greg Keating. Greg is one of the top lawyers practicing in, if I could say, whistleblower defense, but generally in labor and employment matters in the country. Known Greg for some time, and I'm thrilled to have him on the podcast. So, Greg, first of all, welcome, and thank you so much for taking the time to visit with me today.
Tom, it is my pleasure. I'm glad to be here.
Greg, you recently changed firms, and I was wondering if we could start off by you telling us about a little bit about your new firm and your new gig.
Yeah, I'm really excited, Tom. I decided in January to join Epstein Becker Green, which is a national boutique. It's actually a dual boutique. EBG is focused on healthcare and employment. And if there are, two areas to be in the midst of and hopefully coming out of a pandemic, I think EBG is uniquely poised to help employers around the country in healthcare and employment. I have been tasked with starting the Boston office of the employment side of the coin, and we're growing rapidly, and there's a lot of energy, and I'm really excited about the opportunity. It's a firm that's really on the rise right now.
Greg, you've been talking about whistleblowers, whistleblower awards, and whistleblower defense as probably as long as anyone I know. But over the past now 5 months, as we're recording this in mid-May, I think there's been as much conversation around whistleblowers and regulatory changes around whistleblowers as I've seen. And I'd like to start with January 1, 2021, the passage of the National Authoritization Defense Act, which included the AntiMoney Laundering Act of 2020, and specifically the whistleblower provision in there. Why was that such a significant change?
For a few reasons, Tom. First of all, it's engendered some controversy because modeled on Dodd-Frank, the Anti-Money Laundering Act allows for individuals who identify fraud, which leads to a settlement of over $1 million, to collect what is commonly now referred to as a bounty. What I mean by that is the whistleblower not only is protected from retaliation, but if the award is over $1 million, they can cash in on an amount up to 30% of the recovered settlement. So it creates a massive incentive for whistleblowers to collect very sizable awards. And the controversial part of it, as I alluded to earlier, is it allows even for compliance professionals and attorneys, in-house attorneys, to potentially seek and collect those awards. And that's not consistent necessarily with Dodd-Frank, which sets out some very strict and very stringent parameters around the ability for attorneys to ever even collect a bounty. For obvious reasons, Tom, it raises ethical issues around the attorney-client privilege, and in some states like New York, for example, there's a per se bar against attorneys going and collecting bounty awards. So it engendered some controversy. I'll note also, Tom, just as a sort of a timely development, there was a Wall Street Journal article yesterday about the Anti-Money Laundering Act, and many of the plaintiffs' lawyers are at present not very happy about how it's been rolled out for three reasons. Number one, there's no deadline right now for the implementation of any regulatory framework, so it's sort of swinging in the wind right now. Relatedly, number two, there's no designation of which federal agency will actually implement this act. So that creates further uncertainty. And perhaps most significantly for the plaintiffs bar, number three, there's no floor on the amount of an award that a whistleblower can collect. So what I mean by that is, under Dodd-Frank, whistleblowers are guaranteed to get 10 to 30%. And under the AntiMoney Laundering Act, the only thing it says is they can collect up to 30%. So there's no floor. And the plaintiff's bar is sort of saying, this could be a waste of our time because these cases take a very long time to litigate. And if they end up with just a small, 3% award, that's not going to be worth it to them. So it's also significant because it's yet another example of new federal legislation that is protecting and incentivizing whistleblowers. In January, Congress also passed the Antitrust Anti-Retaliation Act, which provides a remedy for any individual who spots and identifies in good faith an antitrust issue and then is retaliated against. There's a continued wave at the federal and state level of new legislation to protect whistleblowers, and this is only fueling the fires of the activity growing in this area.
Greg, I'm a recovering trial lawyer on the civil side of things, and I defended corporations in contract disputes, personal injury cases, and things like that. And would I be cynical in saying that if the plaintiff's bar can't make money, they're not going to file lawsuits?
I don't think you're cynical in saying that. I would embrace the sort of corollary, which is there is so much more money that is flowing out of this whistleblower spigot right now that the plaintiff's bar is absolutely and unequivocally flocking to this area. You're seeing firms that have historically been focused on, asbestos and toxic tort cases who are now moving their engines in this direction because they're seeing that there are, awards not just in the millions, but in the tens of millions of dollars. So it's incentivizing the plaintiff's bar to move in this direction, and they are galvanizing in a big way.
Greg, in addition to the anti-money laundering law of 2020, we obviously had a change in administration. What other regulatory changes are you seeing from the new Biden administration around whistleblowers?
A couple of things. First of all, there's simply no question that we are in for a 4 years of stepped up enforcement. The Biden administration has publicly indicated in an executive order in January, which was sent to the new Secretary of Labor, or then to be, but now confirmed Secretary of Labor Marty Walsh, who was the former mayor of my fair city, Boston. An executive order which really made clear that the Biden administration expects and supports that the Department of Labor will step up with rigor and enforcement against any kind of retaliation against whistleblowers. You also see continued unbelievable success and concrete developments, which I'm sure we'll talk about a little later in the podcast, coming out of the SEC, which administers the whistleblower directorate of the Dodd-Frank program. And just overall, I expect to see increased funding for agencies that during the Trump administration were essentially stripped of their resources and were, had very limited budgets. I served for 2 terms during the Obama-Biden administration on the newly created Whistleblower Protection Advisory Committee. I was appointed by the Secretary of Labor to 2 terms on that committee. And that was an example of how there was really kind of stepped up enforcement and stepped up resources for the Department of Labor. And I would not be surprised. I not only wouldn't be surprised, I predict that the Biden administration is going to carve out increased funding, is going to expect stepped up enforcement. And when you combine that with, as I said, the legislative developments, creation of new rights and remedies, this is an area that is going to blossom and is going to be very fertile over the next 4 years, in my opinion.
One of the things that I've heard you consistently talk about over the years is that companies need to be proactive around whistleblowers, and you have counseled companies to put whistleblower programs in place, but more importantly, to have a whistleblower or have a reporting system that allows the information that comes in to be triaged, evaluated, investigated if necessary. What are you counseling your clients on now? Is it more of that, or is it something different?
No, I mean, I've always said, Tom, you probably heard me say this a dozen times, even in relatively, calm periods like the 4 years we were in with the Trump administration, when other than the SEC doing its thing, which again we can talk about, things were a little quieter. I've always said that the best offense is a strong defense, and so what I mean by that is, in any environment, it's my opinion, counseling and litigating for employers around the country, that it is critical to foster transparency and set in place mechanisms in the workplace so that when people raise concerns, they are heard, the concerns are investigated, and steps are taken, because that creates morale, positive morale. And the converse is absolutely true. If people do not have channels by which to report, if employers do not have investigation protocols in place so they know how to investigate, who will investigate, what will be done, do it in a timely fashion, do not allow retaliation, and lastly, training. So those are the three legs of the stool: the reporting mechanisms, the investigation protocols, and training. I think now more than ever is a time to invest in compliance and not to put your head in the sand and just lay low with a straw in the weeds. There is so much happening right now that it is absolutely my advice that employers should invest the resources in compliance and focus as I said, on those three areas at a minimum, because it's not only good best practices to create a better company to begin with, but in this period of fomenting unrest and huge liability risk, including reputational risk of exposure of reputation to the company and attendant stock price getting hit. It's just absolutely common sense right now that there should be an increase in focus on compliance. And as I said, the best offense is a strong defense.
So, Greg, are there any whistleblower awards, or rather perhaps court cases, that have gotten your attention in 2021?
Well, let's talk about the latter, the court cases. I mean, there's certainly awards that we can talk about as well. But yes, just by way of example, and this the reason this is particularly significant, Tom, is it reflects a trend that is challenging for employers, particularly those that operate in many states, because the law is very frequently divided. The courts are split on certain hot topics around the country. So it's really critical that before any employer takes action in certain circumstances, that they consult with counsel. There was a case out of the Sixth Circuit on April 1st of 2021 called Felton versus Beaumont Hospital. And this was a case that arose under the False Claims Act, which is a federal statute that prohibits retaliation. And the significance of this case, Tom, is the Sixth Circuit held or concluded in this case that a former employee can bring a claim for retaliation based on actions that the employer took against this individual after they left the workforce. So what happened here was a whistleblower was in the workforce, raised concerns, ultimately left, and then someone called for a reference. And the employer gave, I think, a fairly negative reference of this individual. They sued. The employer said, for what? I mean, retaliation is only protected for things that happen to you in the workforce. And the Sixth Circuit said, no, not so fast. We're going to cast a wider net. We're going to provide broader protection. And if actions happen even after employment ends, that will be cognizable. Contrast that with the only Court of Appeals, the 10th Circuit, who had addressed the same issue under the same statute and had held no, there is no relief for a former employee. So the law is both evolving, the courts are split, and as evidenced by this recent Sixth Circuit case, the net of liability risk is expanding, which is consistent with what I said about regulatory expansion of risk and legislative expansion of risk.
Greg, 2002 was the year of the whistleblower, at least Time Magazine called it the year of the whistleblower, with Sharon Watkins of Enron, Cynthia Cooper of WorldCom, and Colleen Raleigh of the FBI. Could 2021 be in running for such a designation?
Oh, absolutely. I've already touched on some of the drivers that are causing this firestorm to really ignite right now: the administration, the regulatory expansion, the legislative expansion, even the judicial expansion of rights and remedies. But I'd add another one, Tom, which is the global expansion of whistleblower protection and whistleblower rights and remedies. Just this year, the EU is going to put into final effect a directive that was announced, I think it was 2019, but it becomes fully effective by the end of this year. It requires all companies in the EU to take certain steps, take certain actions in order to create internal controls to protect people who report in good faith, and creates remedies for those who are retaliated against. You're starting to see countries around the world really, embrace whistleblower protections, oftentimes modeled on what the U.S. has done, not only in its anti-retaliation laws, but even as in the case of Canada, in creating and Australia, creating these new bounty mechanisms that, not only provide that shield for the whistleblower in the form of a remedy if they're retaliated against, but actually now create a sword in the shape of this bounty where they can actually take and collect a piece of the pie when there's a massive settlement with the government. So I think this is definitely on track to be year of the whistleblower 2.0. And we've got the seeds in place for that happening, and they're already sprouting in a big way right now.
Greg, you've mentioned several times the Securities and Exchange Commission and perhaps their greater aggressiveness in accepting whistleblower information and paying out whistleblower bounties. We had a case this week that came down. I was wondering if you could just give us some general thoughts about how this demonstrates really how the SEC has used their whistleblower program.
Yeah, so the case that you're referring to was a whistleblower award that went to an individual in the amount of $28 million. I'll say that again, $28 million awarded to a single individual for raising concerns. These concerns were around bribery and corruption under the Foreign Corrupt Practices Act, FCPA. The SEC has obviously historically been focused pretty squarely on FCPA violations. It was a very hot topic in the Obama administration. It will, I believe, continue to be one, but this award signals, very strongly that once again we alluded to the galvanization of the plaintiffs' bar, and I alluded in the last question you asked me to the global nature of this stuff. This award signals that the SEC's antenna are surely again up for, alleged violations of a statute like that, which often take place in foreign countries. It just so happens there's been a real hotbed of this kind of alleged bribery under the FCPA in countries in Asia. So it's very significant. And in addition, Tom, this is just another example. And it seems like every week as I track this stuff, I'm seeing example after example of the SEC as an agency that is no longer in adolescence, but is in full adulthood. I mean, Dodd-Frank was only passed in 2011. The SEC sort of got up and running somewhat slowly. And there was a trickle of awards in 2014, 15. The trickle turned into a stream in 2016, 17. The stream turned into a river in 18, 19. And the floodgates opened in 2020. I mean, there were, I don't know the actual exact numbers right in front of me, but the amount of awards in 2020 and into 2021 alone are dwarf all of the other awards combined in the first, 8 years of the program. The amount of tips continue to be skyrocketing. This year alone, I believe it was in March, there was an award of $50 million that went to a single individual. So, it is becoming, I don't want to say commonplace, but certainly not out of the ordinary for the SEC under this whistleblower program to award tens of millions of dollars like they did this week to one individual. And that is unequivocally going to continue to kind of, fuel the fires of more activity in this area.
Greg, unfortunately, we are near the end of our time for this episode, but I was wondering if our listeners wanted any more information on any of the topics you've touched upon in this podcast, or perhaps get in touch with you. What would be the best way to do so?
You can reach me at my work email, which is gkeating, Keating, at ebglaw.com. And I'm always happy to field questions or help in any way I can.
Greg, this has been just a great podcast. And as this area continues to evolve, I hope I might be able to call upon you in the future to take us where we might be at that time.
It's always a pleasure, Tom. I'd be delighted to help or to talk at any point in the future with you.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report, a production of the Compliance Podcast Network. We have a great new show on the Compliance Podcast Network called Mo Forecast, which is a podcast of the law firm of Morrison & Forster, hosted by James Koukios. Check that out on the Compliance Podcast Network. Also, we have a new podcast, Survive and Thrive, where with my co-host, Courtney Nordrum, we take a look at compliance disasters, some of the lessons learned and red flags missed, plus what you can do to avoid them going forward. I know you'll enjoy this great new series, Survive and Thrive, which posts every other Tuesday on the Compliance Podcast Network. Thanks so much for listening, and I look forward to visiting with you again next week.